Hello students, welcome to AKS. In this video, we'll discuss about the part 1 of the constitution which deals with the union and its territories. So article 1 to 4 is what we usually discuss now. So let us begin with article 1. Article 1 of the constitution. Article 1 of the constitution declares that India, that is Bharat, is a union of states. Union doesn't mean that India is not a federation, but due to the existence of states, it means India is a federation of states. Okay. Thus, federation was not used literally in the constitution because Indian states have not voluntarily come together to form a federation, like which was the case in the United States of America. The federal process in USA has moved from the periphery, that is, various states came together where the states have surrendered their sovereignty and they transferred certain subjects of governance to the federal government, which are of common interest to all the states. So the process of federation moved from the periphery to the core in the case of USA. In India, it was first the central government or the union government which was established, and then the process of federation moved from the center to the periphery or the center to the states. Thus, in Article 1 of the Constitution, it has categorically mentioned that India, that is Bharat, is a union of states. Mountbatten made it mandatory during the partition. He made it mandatory for the princely states to join either India or Pakistan or remain independent. However, they did not have the privilege to remain independent without any conditions. The princely states were allowed to remain independent only if they satisfied certain conditions. Thus, princely states were geographically and physically as well as economically viable because there is no revenue generation. Thus, the joining of princely states was not voluntary. The princely states were acquired by the Union of India through diplomatic or coercive methods. So it has been mentioned, union has been mentioned in Article 1 of the Constitution. The term union has been mentioned in Article 1 of the Constitution because there was no voluntary agreement between the states to form a federation. Number two, union, the term union was also used to exemplify that India is a permanent union of states where no state has the right to secede. So India is a permanent union, indestructible union with destructible states. This federation is always going to have states. Thus, federation was not used deliberately. Instead of federation, the term union was used so as to convey that India is a permanent union, and thus there was no voluntary agreement between the states to form a federation. And it was a union government which came into existence, and then the states were formed. So that is the reason the term union has been categorically mentioned. Now let us try to see what exactly is there in Article 1. Article 1 states that Bharat is a union of states. And what do you mean? What do you mean by the territory of India? The territory of union. The territory of union. The territory. Territory means territories of the various states of India, territories of union territories, as well as territories that can be acquired by Indian state in future. The Supreme Court in the Berubari versus Union of India case said that East Pakistan can be transferred only by a constitutional amendment, as Article 1 does not mention about seceding a territory of India to a foreign country. Thus, there should be a constitutional amendment. In Article 1, it has mentioned that territories can be acquired, but to secede a territory, to let go of a territory from India, you need a constitutional amendment. Okay, India has thus a territory can be excluded from India only by a constitutional amendment. So originally, Sikkim, the state of Sikkim, which was earlier a princely state, was admitted as an associate state by the Indian Union. Later, by the 36th Constitutional Amendment Act, Sikkim was made an Indian state. It is not deemed as a constitutional amendment. Now let us move to Article 2 of the Constitution. Article 2 Article 2 under Part 1 states about the admission of new states. Admission of new states into the Indian Union. India can admit foreign states. India can establish new states. Thus, there is no need to amend the Constitution under Article 368 of the Constitution. Okay. Then, so when do you consider it as a constitutional amendment, which we will discuss at the later stage of the polity discussions? When we deal with Article 368, we will understand in detail what kind of activity do you consider as a constitutional amendment? What are the preconditions for a particular parliamentary legislation to be called as a constitutional amendment? Now let us try to deal with Article 3 of the Constitution. Article 3 of the Constitution deals with the internal reorganization of the states. It deals with the internal reorganization. Article 2, as you said, it is for the admission of new, foreign territories or establishment of new states. Okay, but Article 3 deals with the internal reorganization. Thus, Parliament under its law can set up a new state by forming a new state or separating a territory from a particular state, uniting any territory to an existing state, or joining two or more states. Okay, these are the various methods. As well as the parliament can form a new state by increasing or reducing the area of a particular state, and also changing the boundary or changing the name of a particular state. Even to change the name of a particular state, you need to do it through Article 3 of the Constitution. Article 3 states about a clear case of internal reorganization. India was federated twice. Once when the princely states joined India between the years 1948 to 1950 and later. And number two, when the States Reorganization Act 1956 was brought into force. What is the procedure? What is the procedure for internal reorganization, and what is the procedure for establishing new states in India, within India? For all the above purposes, under Article 3, a bill can be introduced in any house of the parliament for a new state to be created. That particular bill for the creation of a new state or establishment of a new state within India can be introduced either in the Lok Sabha or the Rajya Sabha. The bill can be introduced only on the prior recommendation of the President of India. Prior recommendation of the President of India. The President sets up a committee before he recommends the bill, which is not mentioned in the Constitution, but it is a parliamentary convention. Usually, before a president introduces a bill, he does not, he recommends the bill only after a committee gives that particular recommendation. It is not mentioned in the Constitution, but usually this is a normal practice. Next, before the president recommends, before the president recommends the bill, the opinion of the state is given to the president in the form of resolution adopted by the state legislature. However, it is not binding on the president. Whatever opinion that the state legislature gives for the partition of a particular state, or for the change of name, or for going off with a particular territory of a particular state, whatever opinion that the state legislature gives is not binding on the president of India. Also, the president fixes the time by which the state legislature has to respond to the request of the president to give the opinion on the matter. Okay, once the state passes the resolution, then the president sets up a committee which makes a report. The report of the committee is submitted to the president, and the president may recommend the bill to the parliament any house of the parliament. It is not binding on the president to definitely recommend the bill based on the parliamentary committee's recommendation. So it is through a simple majority. It is through a simple majority of the then members present and voting, and the bill for the creation of new states can be passed. Under the rules of the parliament, the then members should be at least equal to the quorum, that is 1/10 of the total strength of the house. Okay, the quorum. For example, the quorum of Rajya Sabha is 25 members because the total strength of Rajya Sabha is 250. If you do 1/10 of it, it is 25 members. And you have to pass the bill. So it is through an ordinary legislation that the new state in India can be created. That is, there is no need of a constitutional amendment to create a new state or establish new state in India. So what do you mean by ordinary legislation? Ordinary legislation is such bill which is passed by a simple majority of the then members present and voting in each house of the parliament, and after the bill is passed by a simple majority of the members present and voting in both the houses, it is sent to the president. The assent of the president. See, after the bill is passed by both houses of the parliament, it is mandatory for the president to give his assent to the bill. Okay, because he was the one who recommended this bill to the parliament, and thus he is bound to give his assent for the creation of a new state, for the change in the name of a new state, or for the establishment of a new state within Indian territory. Okay, and Article 111 does not mention any time limit for the president to give assent to the bill. So, though the president is mandated to give his assent to a bill passed for the creation of new states, there is no time limit. He can take his own time to give assent to the bill. Now, let us look at Article 4. Article 4 of the Constitution. So, under Article 2 and 3, whatever, you know, under Article 2 and 3, whatever states which are admitted or created will not be considered. So whatever laws which are passed to create these states or admit new states within Indian territory are not considered as constitutional amendment because it has been passed by ordinary law of the then members present and voting in the parliament. Okay, and thus it is not making any changes in the constitution. The operational jurisdiction of any article in the constitution is not affected, so it is not deemed an amendment to the constitution. It can be examined by the courts under the however it can be examined by the courts under the process of judicial review. Now let us come to Article 4. The law passed under Article 4 will not be deemed as an amendment to the Constitution as we are passing it by an ordinary legislation with a simple majority and not by the procedure under Article 368. So the law passed for the creation of new states under Article 3 is not a constitutional amendment, is what has been mentioned in Article 4 of the Constitution. So that is about part 1 of the Constitution from Article 1 to 4. Thank you.